Good afternoon, everyone. Welcome to the DocketWise webinar. I'm James Pittman, co-founder here at DocketWise. Today's topic is ethical considerations in immigration practice. And I have with me two practicing immigration attorneys. I have Eric Singer from Maryland. I have David Cox from Illinois. Both of these gentlemen are actively involved in immigration law practice. As an aside, I was previously in immigration practice. I am no longer in practice. But these two gentlemen are currently in practice. And, you know, the topic of ethics is very important, obviously, because law is a regulated profession. And we're going to talk about, you know, what these principles mean, how they apply in the immigration law context, how you should approach them to make sure that you don't get yourself into trouble, how to protect yourself, and how to do right by the client in light of the ethical guidelines that we've been given. And let me just start out by talking about the sources of ethical principles. Of course, the starting point is always your state rules of professional conduct. Ethical rules vary, and they have shades of variation, and then they've been interpreted by administrative decisions and sometimes court decisions in the various states. And you should always refer to the ethical principles of the state where you are practicing, but also with a nod toward the ethical principles of any other state where you are licensed. The American Bar Association, which is of course a voluntary bar association, has come out with model rules that have been out for many, many years. And those are sort of suggestions to the states for how to implement ethical rules. And we're going to be, because we have viewers that are joining us from many different states, I've sort of listed topics as they sort of come up in the model rules, and then we're going to talk about them without, for the most part, without going, in too deeply into what a particular state's interpretation. That'll be mentioned, obviously in the context of us talking about our previous experience, but with a nod toward what's embodied as a general ethical principle in the model rules that states may have adopted. With regard to immigration, we also need to be cognizant of immigration-specific ethical regulations, and those are contained in the Code of Federal Regulations. For those of you who want the citation, it's 8 CFR 1003 at 1003.101 at sequence, and those spell out specific requirements that you must observe when you are handling cases in front of the immigration courts, the Board of Immigration Appeals, the USCIS, and other components of the Department of Homeland Security. So having said that, if you have questions, whenever you have questions, feel free to post them in the question and answer box, and we will answer them as they come up. I'm going to start off by talking about competence. Competence is 1.1, rule 1.1 of the model rules. And with regard to immigration, it's as a note of caution, people who are not well versed yet in immigration should exercise some degree of caution. This is true, whenever you're going into a new practice area. But with regard to immigration, you need to keep in mind it is a complex area of the law. It's obviously not simply filling in forms. There's an entire statutory and judicial body of law underlying, what those forms represent and the benefits that you seek to gain by filing those forms. And you need to know, those laws. So while you're getting up to speed, if you're new to immigration practice, it's wise to seek mentorship, associate with experienced counsel. You should have a sense of the relative complexity of an immigration case before you undertake the representation. Sometimes a case that looks like it's pretty straightforward at the outset can turn into a complicated case. Complications arise, and it can actually turn into a different type of case. You might start out with what looks like a straightforward family-based adjustment case, and it turns into a VAWA case, or it turns into a removal case. And if you're undertaking something that's complex, for example, one of the types of cases that does get complex is where you're dealing with removal proceedings for people with criminal convictions. You should obviously make sure that you're very familiar with, the relevant law. You have to be cautious of removal proceedings if you're unfamiliar, simply because the consequences of failure can be extremely grave for non-citizens, and also can open up the door for you if you cause the person to get a removal order, can open up the door for an ethical complaint against yourself. Let me turn it over to our guest now and talk about the concept of competence in immigration law. What does that mean? Either of you gentlemen, who'd like to start?
I'll go ahead and start because the first thing I thought of as you were describing the importance of being competent in this area of the law is not only the point you already made that it is probably unique as an area of law for having tricky things to maneuver around. It's tricky enough that many immigration lawyers don't get it right. And I learned that from interviewing clients who are looking to switch attorneys. And during our intake interview, they often will tell me the name of the attorney. That helps me analyze it, I suppose, a little better. But I'm really always caught off guard by what I notice some of my colleagues are doing in this area of the law, even though they are, for the most part, practicing exclusively in the area of immigration. Some of them may be adding some other minor practice areas, but that wouldn't explain a lack of competence. And certainly the rule applies to any attorney, whether they're dabbling in immigration, whether they're full-time immigration, or breaking it into 2 or 3 different areas of practice.
Absolutely.
Yeah.
Eric, would you like to add something?
I don't think you can overstate the importance of that, the competence rule. Like David, I'd say perhaps a little bit more than half of the clients who come to see me are coming from, they've already had a bad experience or a different experience with prior counsel where mistakes have been made. But I'm not tooting my own horn on that point. I'm sure, I hope that I myself have never been one of those named by clients seeking other help, but I'm sure that's happened. And I suppose I'd offer this rule of thumb, certainly for removal cases in particular. I'd always, no matter what your level of competence, I'd always try to run the case by at least 2 other reputable colleagues or sources to make certain you've thought through the full litigation path, you're aware of all the remedies, all the burdens, all the challenges, particularly on asylum cases where theories of the case are evolving, particularly in the matter of particular social groups and so forth. So yeah, to sum up my point of view on competence, I'm limiting it expressly to removal proceedings in particular. That would be my rule of thumb to offer. I don't care if you've been practicing 25 years, you shouldn't be taking the case or taking it on or proceeding with it until you've gotten two other viewpoints from other colleagues, just to make certain you're not missing something.
And one of the places that you can look if you're just getting into the area, you may wish to join certain Facebook groups for immigration lawyers. I've seen that people on some of those groups, I can plug Nerdy Immigration Lawyers, Nerdy, N-E-R-D-Y, kind of a funny name, but it's a great group with thousands of members, and people are, for the most part, very open to sharing experience. So, you can post the fact pattern, or you can, make acquaintance with people and contact them outside of the group to ask. And in that way, you can build up a network of people that you can run by the cases by before you take them on. So excellent advice from both of our guests. Let's talk about scope of representation. It's very important to define for the potential client what the scope of the services is that you're going to be providing. And one of the ways that you do that is by using attorney-client agreements or engagement letters. This is embodied in Model Rule 1.2. The attorney-client agreement should spell out what applications will be filed, for immigration purposes. If the case involves multiple stages over a long period of time, which stages are you including within the scope of the present representation? And again, with removal proceedings, if the case could take a turn, if it starts off as an affirmative, let's say affirmative asylum application, someone comes in, they want to file asylum, they're not currently in removal proceedings, you file an I-589, we all know that a denied I-581 for someone out of status is about the fastest path to removal proceedings that there is. So has your attorney-client agreement spelled out whether you will be representing them in removal proceedings should the case actually go in that direction? You do want to always mention that appeals are a separate matter. And limited scope of representation is permissible, at least under the model rules, if it's justified. For example, the client may wish you to prepare and file their N-400 for their naturalization, but they they may not want to pay for the attorney to come with them. If it's an uncomplicated case and they've had friends and relatives who have gone and done their citizenship interviews themselves without counsel and done it just fine, they may ask you if you'll agree to that arrangement, and that will be up to you. But certainly, your decision should be made in light of the facts of the case, and whatever decision you make should be, embodied in a writing that you get the client's signature on. Let me open it up to our guests. Either gentleman want to talk about scope of representation?
Well, I'll just offer up that I think this is an area where I take a lot of pride. I must spend about 20 minutes at least at a minimum in drafting my agreements. Believe it or not, I end up individually tailoring them all the time, regardless of how bread and butter the matter is. Some exceptions, but I really spend a great deal of time actually in drafting the agreement. I almost feel as if I should be compensated extra for the time I spend in drafting it, and sometimes I do take that into account somewhere along the way during representation, especially if the matter is quite complex.
Eric, how many pages? How many pages could the engagement letter be?
Yeah, it's not overwhelming. I've seen some egregiously long ones. Mine will vary from 3 to 4, but it's the scope of representation that is the first paragraph of all my attorney-client agreements. And it's very, very carefully defined because I don't want to get into a disappointing situation or confusing situation where the client thinks I should be doing this or thinks I should have been doing that under the terms of our agreement. Remember, I'm almost in all cases, except in federal court litigation, working off a flat fee, often always against myself. I'm not the savviest negotiator. So I've got to be very careful that I'm not ending up burdening myself with work that I'm not compensated for. This is tough because I do this in multiple languages, and really some of the fine points, some of the exclusions that I draw out in bold, have to be very carefully thought through. So yeah, very important point to the client to understand that this is a governing document that governs our relationship, and they know the full scope of what I'm not going to be doing, at least for the particular flat fee that's being offered.
David?
Yeah, I was just going to add that the scope paragraph, and it sounds like Eric also does this, has kind of 2 sections. Here's what I am planning to do for you in as much descriptive language as you can create as a good lawyer. In other words, I do the same thing as Eric. I don't have those pre-printed. I rewrite that section of the scope paragraph myself every time, because I want to make sure it correctly reflects the conversation I've had with the client and exactly what I want to be responsible for doing and what I don't want to be responsible for doing. And then there's a second section of that paragraph where I say the scope of representation does not include things like appeals, motions to reopen, reconsider, and I clearly state those services are available under a separate fee agreement if they come up. So we all follow, it sounds like Eric and I at least follow best practices in that regard. I list my fee, which is always a flat fee as well, how many payments they can make to pay my fee. The reason I do that, by the way, is because the state of Missouri has a threshold under which you can go ahead and charge a flat fee without putting the funds in trust. So in order to meet that, I divide up whatever my flat fee is into increments that meet that requirement and avoid me having to use my trust account to track the funds. So so I put that also on the front page. It's not in the scope of services paragraph, but that's important, of course, for clients to understand exactly what this is going to cost and what it's going to cover kind of together. So I make sure that's all included in there. And I also describe the fees. If it's a simple case where I know what the fee is, I'll just quote it. But a lot of cases, I don't want to spend all the time talking about the various possibilities of where fees are going to be due or not due and what they are, because they change all the time. So I use a more generic phrase in my agreements to clarify that, to basically explain that fees payable to a third party whether that's a government agency as a filing fee or a company that does translations or whatever it is, and they don't want to pay the person directly themselves, that those are not included in my fee. And I've not had much trouble with that. That seems to be pretty clear to clients.
Well, gentlemen, what about the government filing fees? Do you spell them out in the retainer agreement, and how do you have the client pay those?
Yeah, I don't, because they vary so much, and my fee agreements are generic to any representation other than that scope language, where I do list all the forms I'm filing. But I don't go through the effort of saying, well, this form costs this much, this one costs this much. Maybe I should, but I've never done that.
I do that, but I also am careful to note that the fees are subject to modification, increase at any point. And in my case, I always try to make certain the client understands that I'm not advancing fees, that they're directly responsible for the payments. I just find that much simpler than taking a kind of fee payment and putting it in trust and then having to pay it myself. So that's generally worked for me.
Do you have them hand you a money order, or payable to the DHS, or? Well,
I instruct them later in the process, of course, whom to make filing fees payable to if they're not going to be using a G1450. If they're not going to be using a card.
Yes.
But yeah, I try to make that pretty clear. I can't afford to. In my case, I'm so small that I cannot really afford to advance funds toward fees. And so, as in David's situation, I mark that out separately for them to take care of on their own.
All right. Let's talk about diligence, acting with diligence, being conscious of filing deadlines. When you're practicing immigration law, you will have deadlines. You will live and die by deadlines, such as responses to requests for evidence. You may get a request for evidence that can, if it's mailed to you, they'll usually give you 87 days to file a response. If it's handed to you in an interview, often it's 30 or 33 days. A particular deadline that's of extreme importance is the deadline for filing an appeal with the BIA, and that has to be received within 30 days of the date of the immigration judge decision that you're appealing. That is not a mailbox rule, but is a receipt rule. They have to actually receive it in the board's office within the 30 days. So you should be sure to use a courier that gives a tracking number. And there have in the past, and there probably still are, same-day filing services in Falls Church, Virginia. If you are running up against the deadline, it is well worth your while to simply pay the extra money to have someone actually walk your filing over there to the BIA office to be sure that it's received in time. There is no cure in general for being late for BIA filing. You also want to be aware of the expiration dates for the client's immigration status and make sure that you file applications for renewal, petitions for extension of status on time. To do this, you need to use a case tracking system. Hello, everyone. We're DocketWise, or at least a well-organized online calendar to keep track of dates. Let's talk about deadlines. Let's talk about keeping track of deadlines, meeting deadlines with our guests. Either gentleman.
I'm going to let David go on this one first.
I use DocketWise.
Okay, wonderful. Let's hear that.
But what I'm really checking to make sure I don't miss a deadline is the calendar I look at every day, and that is my operating calendar, which happens to be the one that I use all Mac devices. So it propagates across all the devices, and I have it on 2 different telephones and multiple computers, and all of my employees, not that I have that many, I have 3, they can see the same calendar all the time and can know what's going on as well. So the other advantage I get out of that is I just started using software to allow my clients to make their own appointments through a intelligent scheduling system. So I can plug in all kinds of rules that prohibit them from making appointments when I don't want them to, but it provides them a clean, protected view of when I'm available, and they get to just click on those. And since that's all one calendar that I'm pointing to, it gets my attention all the time. And so when I put a deadline in there for an RFE, for example, or an appeal deadline, or a deadline to respond to a motion to reopen or reconsider, I'm seeing that all. In fact, see it come up, because I always use the monthly view or the weekly view of the calendar that allows me a broad perspective of what's coming up and what deadlines I have. So I use both programs for that.
Let me give you a difficult situation. Suppose you're coming up a deadline for, filing for an extension of status, and you just haven't heard from the client. They've been out to lunch. How do you do that as you're getting to the last couple of days before your filing deadline? What would you do? Besides try to call them on the phone. Have you ever had that happen?
Yes, I have had that happen. Other than try to call them on the phone, though, I guess telepathy, I don't know. I just get on the phone and try and reach them, other people that I know from the case that know them. If I have their phone numbers, I'll try to reach them that way. And then I'll do as a final effort, I'll write a letter and send it by FedEx overnight saying your deadline's tomorrow. If I don't hear from you, you're going to miss it.
Mm-hmm.
I often go maybe one other step and actually do it. In other words, if I'm pretty confident the clients are, still living and breathing, and I cannot reach them by any human means, it's been the case that I've often eaten the fee myself, temporarily, provisionally, and done whatever filing I can, especially if it's an appeal deadline, where I don't need a signature. I might even do it in cases where I have needed a signature and somehow go back and ask for some nunc pro tunc grace.
Gotcha.
But I've done that. Interesting ethical question. I think David's probably right on the point, which is you owe no duty, apparently, if you've communicated sufficiently with the client about the deadline and they fail to come through and live up to their own terms. My clients, they're not often able to communicate that well for whatever reason. So luckily I've never, only once I think I paid an appeal fee for an appeal where the client truly did disappear. So a small cost to pay on my part to try to protect them to the maximum, and myself too. But they truly disappeared. They ran off and relocated in Arizona, I learned. And
let me just add,
they did not want to pursue the appeal. Of course, the appeal ultimately was denied, for abandonment of filing a brief and so forth. But I feel good that I did it.
Let me just add this perspective too. If filing an extension was already described in the scope of services, then I too would just proceed. But if that was covered by our fee agreement by the exception, in other words, that's not included, and the client may well have wanted to hire me as a separate matter to file that action, an extension, for example, then that's when I would do what I described earlier, where I would just try to find out, contact them, because I wouldn't feel an obligation without that fee agreement in place to just take that action without their approval, because they also, have a right to say no.
Right.
A reason to say no. So, but I would, if it was covered by a scope, or even if that was some kind of verbal discussion where I said, I'll do it, and we just never got around to signing the fee agreement, which would be a bad thing ethically, of course. But if that's what happened, I would probably just take action myself to avoid a situation where nothing happened and the client's rights were adversely affected.
Very good. Very good points. Let's move on to communications, also very important. It kind of shades into what we were just talking about. Communications. I mean, as a general principle, clients love to hear from their lawyer for the most part. Whenever possible, paper them to death. I mean, nowadays, some of it can be electronic scanned copies, but you should be providing the client copies of everything that you're filing, copies of applications, petitions, other forms filed, copies of your correspondence with the Immigration Service. You do want to promptly notify the client when an action has issued on their case, and make sure that you provide the client with a copy of whatever you received, whether it's a request for evidence, whether it's a hearing notice, or what have you. You want to strive to return client phone calls the same day whenever possible. If you just cannot get to it personally, you should have someone else call the client back on your behalf, your paralegal or receptionist, and at least find out what they want. You want to set parameters if clients are making an unreasonable number of phone calls. You should consider appropriate modifications to your own workflow and office processes in your office if you find that the communication is getting excessive. And it bears repeating. It's been said before, but it bears repeating every time. Failure to communicate with your client is the #1 cause of ethical complaints filed against lawyers. Gentlemen, how do you manage communications with the client, and especially if it gets overwhelming?
Well, I don't know how many people on the call are like myself, true sole practitioners without much support staff at all, but relatively speaking, that's my problem. And so I have to make an extra effort in communicating up front that I can't really often meet the expectations that they might have to communicate as rapidly as they might expect. So I try to set a rule where I'm going to try to return a call within 24 hours or 48 hours or so forth. And I'm going to have to try to instruct clients who are hounding me that unfortunately my practice is not one that allows for that kind of level of communication, at least in the beginning. Maybe that's a flaw of mine, but as a sole practitioner with a certain caseload, I cannot take 3 or 4 or 5 calls from the same day from the same client when the matter is not an emergency. So I have to be fairly diplomatic in setting the ground rules.
Eric, do clients ever have?
Most of my client communication, therefore, I mean, because I'm not able to pick up the phones constantly, and it's in my client agreement, has to be done through email. That I can handle, volumes of. I'm not disturbed by that. But it's not surprising that a client might think that, I'm a doctor's office, and why can't I call the doctor 3 or 4 times a day? Surely the doctor has the staff and the ability to handle my calls, and surely that doctor will turn around my matter within 48 hours. So I have to sort of set expectations from the beginning, clearly, because I think any client would come in not with a clear conception that I'm as small as I am. I don't have any problems, I think, meeting my duties of communicating with them. Certainly, looking at some of the bullets you provided in your background outline for us, I'm good about getting all that information out, getting them a scanned copy of everything that goes out right away after it goes out, and so forth. But I do have that first challenge that I mentioned, which is I've got to sort of set boundaries for my clients.
The challenge I find more difficult is in this area of practice. I mostly do family-based immigration, although I do other things as well, including removal cases. But in family-based practice, processing deadlines or processing times are so extended, and nothing's happening. You'll file something, and we'll be in touch with the client many times, sometimes many times a day, as we're getting a final package ready to send off. And then we send it off, and of course, they're used to hearing from us all the time, and now all of a sudden silence. And there's nothing to tell them other than we're waiting 6 to 8 to 10 to 12 to 16 to 18 months for whatever kind of application it is. So that's also something that I try to when I'm meeting with client back before COVID, when I was meeting with all of my clients in person before they signed their fee agreements. I don't do that now because of COVID. I send it all out electronically, and need to find a way to have this conversation with them anyway. But I tell them that. I say, look, here's what's going to happen. We're going to file this citizenship application or this application to remove the conditions of your status, and it's going to take X long to adjudicate. And we're not going to hear from immigration. And at the same time, there's nothing for me to update you with, so you're not going to hear from me. So I tried to warn them about that. It still doesn't work. I get clients call me all the time or email me usually saying, I haven't heard from you for 6 months or 8 months, and I'm upset. And it's always, it's not something I'm doing or neglecting, other than keeping them updated. But it's frustrating to have to update multiple clients with that there's no change. It seems like you almost have to do that to meet this human condition of a need to stay in touch with the professional you've hired to represent you. So I struggle with that. I still try to find a good way to deal with that. And like I said, it worked better before COVID, when I could have a personal look them in the eye and say, look, you're not going to hear from me for 8 months or whatever until we hear from them. But then, of course, I do always update. As soon as I get anything in the mail, I give it my copy, and or I scan it and send my client a copy of what I received. So we're on top of everything else. It's just that one thing that I find particularly difficult, and it is the most dangerous thing because it could lead to a complaint. It's the one thing that can lead to a complaint more than any other. So I probably need to rethink whether I make regular contact with clients just to tell them we're still waiting.
And I'll just make a mention from the case management standpoint that inside of our platform, DocketWise, you are able to utilize a couple of features to try to make this a little more bearable. You can utilize the matter workflows, where you actually create a type of case and break it down into stages and estimate a time frame for each stage. And if the case exceeds the estimated time frame at any point in the process, it would be marked late in your DocketWise account, and then you'll be able to run the filter and find all cases that are, outside of the time frames that you yourself have set for the matter. And then you'd be able to send an outgoing, quickly trigger an outgoing message to the client, which, if you're using the standard version of DocketWise, could be an outgoing email. If you're using DocketWise Suite, it could also be a customized text message that you've templated ahead of time. So I will mention that helps as well.
If you don't mind, let me raise something also on the point of communications, namely a substantive point that I've learned the hard way, which is that many of our clients, not surprisingly, might not understand vital things that need to be communicated, including about the scope of work, even with a foreign language interpreter, if you need one. So if you have clients that might not have had more than a second or third grade education from Guatemala, let's say, shouldn't expect them to even understand what the notion of an appeal is or what it involves. And so if you're having communications about strategy, you've got to be extra certain that you're not just using an interpreter if you need one, but that your clients actually understand the concepts, what the concepts mean. Because if they don't understand and then you disappoint them later, of course you're going to get a bar complaint later.
Mm-hmm.
That, my client failed to explain to me what such and such meant. It's
and Eric, if that's
rather serious
concern, if that's a real concern in a particular situation, would you have the client in the office and have it explained through an interpreter? Would you have the client sign some sort of a memorandum of understanding, to signify that you did explain it to them, or how would you handle it practically?
Well, that would be ideal. I think the first thing that you've got to be sensitive to is that you and your client might not be communicating honestly with each other about what the meaning of certain terms are. Your client might be too embarrassed to express that they don't know what an appeal is. So you'll never know that they don't know. This becomes very dangerous. So maybe as a rule of thumb, it does make sense to go the extra mile and sort of lay out in as basic terms as you can what certain legal terms of art mean, what they mean in practice. And then, of course, sure, to document it with a separate memorandum.
Mm-hmm.
Of course, that would be a good idea. In my case that I'm thinking of in particular, yeah, that would have been very, very helpful. But I've learned that lesson painfully. And I certainly will never, ever make that mistake again.
Mm-hmm.
Yeah.
All right, very good. Very good discussion here. Let's talk about fees. Obviously, a topic everyone likes to talk about, or at least thinks about all the time. Fees must be reasonable. And how do you determine what's reasonable for your fee? Well, there are some factors that you should consider. You should consider the novelty and the difficulty of the work, the geographical location where you are, and your own level of experience. You're also going to have to consider what the market can bear and what your colleagues are charging. That plays into the geographical location. You want to spell out the fees carefully, obviously, in your agreement. Some people will itemize the government filing fees. Some in the agreement we talked about this. Some people don't. I tend to think it's a good idea to itemize them and also put a disclaimer in there that they're subject to increase without warning. Flat fees, flat attorney fees are most common in immigration. You should be aware of your local rules for whether a fee can be considered earned when paid, or does it have to go into the trust account? You need to know what your local rules say about that. It's very important. You have to comply with state rules for when advanced costs must be placed in trust. You can consider simplifying your practice by having clients pay third parties directly whenever possible. Contingent fees, not customary in immigration law. I don't think you want to go there. Tell the client, you'll pay me double if we win the case. I don't think you want to go there. Not heard of anyone doing that. Doesn't sound like a good idea. Hourly billing may be appropriate in some instances, potentially in a litigation context, potentially if you're handling matters for a corporate client, you may want to bill hourly. I think you should get to know your peers and what the customary practices are for that type of case in the geographical area where you're located. Gentlemen, apart from what we've already said about fee agreements, anything else you want to add about fees, reasonable fees, dividing fees, and anything on the topic?
Well, I just know I'm in shock sometimes when a client who's been further out in the world than where I practice, places like New York and Miami and Los Angeles and Chicago, tell me the fee that they were quoted or paid, depending on why they're talking to me. I can be shocked, and that's a rare thing. So that I may be a good litmus test for whether a fee is a reasonable fee or not. Because when I calculate my fees, of course, I'm talking to colleagues and trying to get a feel for what the market is like for these kinds of fees here where I'm located. But what I try to do, because I also have to explain to my clients why the fee is reasonable. They don't all ask, but I want to be able to articulate to them why. So I have come up with a rough description of why my flat fees, they're all flat fees, why the flat fees are what they are. And I tell them that I have an hourly rate, that I try to calculate how much time a case takes based on that hourly rate, and then set it as a flat fee. And the advantage to a flat fee, of course, is the price doesn't go up or down, and who gets the best advantage out of that depends on, events that haven't happened yet. So most people are prepared to take the possibility that the fee is a little higher than I would have otherwise charged if the work gets done faster than we expected. Most clients are willing to accept that trade-off. But I do like to be able to tie my fee to an hourly rate, even though I'm not charging by the hour. It helps them understand and internalize why it is a reasonable fee. And once we've had that conversation, they're far less likely, of course, to file a complaint saying their fee was unreasonable.
I'll add in our platform in DocketWise, even if you're writing an invoice, if you're adding a flat fee, I will mention that you can time yourself regardless, even if you're not planning on billing hourly or billing flat, but you're still timing yourself. It becomes very good because you can go back and review all the time entries that you put in for a particular case and evaluate whether your flat fee was on point. If you've charged the client $1,500 for naturalization and in the end you've spent 12 and a half hours on it, you may need to rethink how you're calculating your fees. Eric, you want to add anything on top?
Just to follow up on what you said, James, you've got to do that, unfortunately, or I have to do that, unfortunately, in the event of a termination, because in my agreements, in most circumstances, I provide for a different resolution of my fees if there's a termination.
How does that work?
Well, I'm going to go, it resorts to an hourly.
Mhm.
Certainly, I have to decide when that hourly would kick in after whatever flat fees they've provided. If I've ended up overworking a case, I'm going to try to recoup my fees if I've been terminated and I haven't really been paid in advance the sufficient flat fee for the work I've done. So if a client pays me $500, but I've ended up doing $2,000 of work and then suddenly I'm terminated, they're going to, under the terms of my contract, which I've only once enforced in this regard, I'm going to present I'm going to present a detailed billing statement of my time spent. And that's going to be multiplied, to the 10th of the hour by 350. And they're going to get a bill. They're going to get a bill for that. That's what they've signed up for. Because they've gotten my work product. And I've decided that in the event that occurs to me, I'm gonna be paid on an hourly basis. I also wanted to push back on your contingency idea just for a second. I haven't thought it through, but there are cases where I've had clients that are or purport to be, particularly poor, and the task has been very challenging. So let's say on a naturalization case where I've had a client with an extensive criminal record, I have made deals with clients before that, by the way, if we win, I get a bonus. I'm undercharging you grossly on a flat fee basis for this work. You protest that you want to have me as your lawyer only, and you won't let me go. And I'll say, fine. If we win, I get an extra $2,000. Given your extensive DUI history and your domestic violence case against your wife 7 years ago. So that's a contingency, isn't it?
It is.
Of course, I've not thought it through. I haven't thought through the ethics of that, but they don't strike me as flatly inappropriate for me to receive that kind of bonus.
I think it would. I think it depends on. I think it depends on how it is presented to the client, what they understand the contingent condition is, what the amount of the payment is. So and all of those factors, I think, could turn it one way or the other. How do you handle fee disputes? I mean, what do you do in a fee dispute? Do you sue the client? I mean,
I used to years ago, but it's been over 13 years or so since I've ever done that. I have an arrangement where we mediate. We go to our local bar association.
Okay.
I've never had to use that in years, ever. But it's no one sues anybody. We take it to a we would take it to a fee dispute resolution committee provided by our local bar chapter.
Mm-hmm. Now, is that required under the rules? Do they require you to do it that? No. Okay.
No, I think it's the smartest
better
for both parties. Yeah.
So I structure my flat fees in a way that they're always timed to coincide with a milestone in the case. So for example, going with a couple to an interview for a green card, that's when the second payment of my two parts of the flat fee are due. So if they were to say, I don't want to hire you or I can't pay you anymore, my response is, well, I'm going to withdraw from representing you because you haven't paid my full fee. And that will mean, of course, that I'm not going to be with you at the interview. So that usually results in payment. So
right.
I've never had to even consider suing a client, and in a few occasions where clients remained obstinate and would not pay, I was able to withdraw without losing money because of the way I timed those flat fee payments. So that seems to work well for me. But
me too. Yeah, I have the same system and it works. I've never had a fee dispute on a flat fee basis where it's struck by milestone.
I think it's a common practice and a good practice. And I guess you should check your bar association. Those fee arbitration committees are a common feature of many bar associations. So I think for all of our listeners, just obviously be apprised, research that and be apprised of whether that is something that's voluntary, whether it's something that's mandatory. I just check into it and know when you need to use your bar association's fee dispute committee. All right, let's talk about confidentiality of information. This is the big one. Immigration law requires collecting a great deal of biographical information, much of it sensitive information, social security numbers, dates of birth, maiden name, things that are commonly used as identifiers when you're trying, for example, to log into any type of secure platform. You're commonly asked for your mother's maiden name or something like that. So a lot of this information is quite sensitive, and you have a duty to keep it confidential. What should our listeners be careful about? In other words, what do you look out for to make sure that you're keeping the client's information confidential?
Well, the biggest challenge I face in keeping client information confidential is when it's a referral case, and they want me to confirm that I represented so-and-so who referred them to me, or how well their case went, or whatever it is. My understanding of the rule of confidentiality is I'm not allowed to even reveal that I represent somebody. That itself is a confidence that my client would have to waive before I could share it with someone else. So when someone comes in on a referral and says, hey, so-and-so, sent me to you, you know who I'm talking about? Did you represent them? I find it difficult to answer those questions. Sometimes I'll say things like, the name sounds familiar to me, or something that's not quite a right answer that might get me in trouble later. So that's when I find confidentiality difficult to deal with. I don't find the thing most attorneys worry about in today's modern world to be a problem, and that is technology. A lot of people are like, well, emails and texts, or whatever new technology we're using to share information with our clients or other people somehow changes these rules. I don't think it does. I think the advent of email resulted in us viewing technology as somehow tweaking or changing or requiring further explanation for the rule of confidentiality. And I just don't think it needs that. I think every form of communication, whether it's an email or a text message or even an in-person conversation or a phone call, can be hacked, can be compromised as equally as every other. So I don't think we have to be warning clients, well, this is going to be a text and that's particularly troublesome, so I'm warning you in advance, that this is what I'm going to do. I just think we tend to overprotect technological solutions to communication when the rules don't really require that. And we're seeing that more and more often. A lot of the bar associations are either not enforcing or removing their email disclaimer messages because of that. Basically, it doesn't serve any valuable purpose because of how vulnerable all our communications are all the time. It kind of reduces the level of concern and makes it equal for every form of communication and easier to protect in that regard too, legally.
Let me mention that, and nowadays, the way that, for example, if you're using a case management platform, like ours, the case management platforms are hosted on, or they should be hosted on, state-of-the-art, business servers. Ours, for example, is on Amazon Web Services, where they have an entire panoply of very, very powerful data security technologies. So long if you have, as the attorney, have done your due diligence and verified that the solution that you're using is using state-of-the-art data security, you've covered yourself. It's no different than if you, in the past, where things were hosted locally, you had to, I think, worry more about that. And that is no different than, if you had data in your office stored on an insecure local server, that is not different than if you left paper files lying out in the open. That's the same idea there. But I think to follow up on what David said, the technology has gotten to the point where reputable providers of data storage and case management solutions to attorneys are, for the most part, using cloud-based platforms, which have very high levels of security, such as Amazon. Eric, do you want to chime in?
Not really. I'm just facetiously want to, I'm counting on DocketWise to to maintain,
Well, we won't let you down.
make certain no one's going to hack into my client's data.
It's an extremely high priority for us, and we are housed on Amazon, which does provide 32-bit encryption and numerous other data security features. Users can read our terms of service and privacy policy and always ask us any question about data security if they have any. Let's talk about conflicts of interest. This is a very important topic that we simply must cover. Conflicts of interest, so this is where you should not or cannot, you must not represent someone whose interests are averse to one of your clients, and it can be a current client, it can be a previous client. Let's talk about conflicts of interest for a current client. Conflicts of interest are potentially present in both the family and employment-based immigration contexts. For example, in a marriage-based case, if you're going to represent both parties, which is normal, it is a good idea to have them sign a disclosure and consent to joint representation. You're jointly representing both the petitioner and the beneficiary. You may have that language in your attorney-client agreement. You may have a separate memorandum of a disclosure and consent to being jointly represented. Just to follow up on that example, be careful when the marriage breaks down. For example, if you're engaged in a joint representation in a marriage case, discuss the implications and limitations with the client. If there's domestic violence or the marriage breaks apart for another reason, sometimes the beneficiary will want to file an I-360 under the VAWA provisions, Violence Against Women Act. You'd have to, for example, you'd have to refer that client elsewhere because of the nature of the accusations which would be made would be materially adverse. You could not represent the beneficiary in continuing the case with an I-360 when you've already represented the petitioner, because they would be making accusations that are, accusations that are against your other client, your petitioner. You cannot represent one party in a divorce. If you're also practicing family law, you can't represent one of the parties in a divorce after you've jointly represented them in an immigration case as a general proposition. In the employment-based context, you want to be aware of the potential conflict if you're representing an employer. For example, in the first stages of the case, you're representing the employer in a perm and in an I-140, and later you're representing the employee in the adjustment of status stage. Some attorneys avoid the conflict by only representing the employer. They don't want to be bothered to represent the beneficiary if their client is the company. So let's talk about conflicts of interest, gentlemen. How do you see them arise in immigration context, and what do you do about them?
Well, I was going to throw out a juicy anecdote and hypothetical.
Yes.
For the crowd. This is kind of a hypothetical that's information, and it involves a conflict between former clients. All right, the hypothetical is this: that Joe is a U.S. citizen married to Jane, who's, let's say, a Russian national. They succeed in having Jane adjust her status. Jane separates from Joe the day after she gets her green card. A year later, Joe learns from a mutual friend who set them up and who was later prosecuted in his own right for his own marriage fraud, that in fact the whole setup between Joe and the Russian woman was the whole arrangement was a setup. Jane merely entered into the marriage for the immigration benefit and only did so. Their mutual friend was paid by Jane's parents back in Russia, who are Russian oligarchs, who paid big money to this third party who set them up. Joe is furious. Joe wants to write a letter to USCIS indicating that his ex-wife obviously married him fraudulently and would like to do so that her naturalization will be blocked. He wants to do this just as a matter of retributive justice. But once upon a time, you represented Joe and Jane as a couple. not knowing any better. You may have received confidential communications. Can you represent Joe in simply crafting and presenting the letter to USCIS, indicating he believes, based on documents that he's received from these third parties, that the marriage was a fraud? Essentially, you're clearly, you're taking a leap
Mm-hmm.
on the notion that the fraud can be firmly proven and supported, but you're going against a former client.
Right.
Jane, can you do it?
Isn't the rule for previous clients, you have to get the client's consent in writing?
What if you feel that a criminal fraud was perpetrated, though,
Mm-hmm.
and that you have a clear case of criminal wrongdoing perpetrated by your former client? You're not going to get that. You're not going to get Jane's consent in writing.
No, obviously not. Yeah. How did you handle it?
I haven't handled it yet.
Okay. Oh, it's a hypothetical.
I'm thinking about it. It's real, though. It's real. If I hand it off to another attorney, I mean, still, that attorney is basically acting as a cutout for me, in a sense. What do I do? What's the threshold of proof I need, if any,
Mm-hmm.
to be able to act adversely to a former client? Because I clearly am acting adversely to a former client.
And the one that's coming in, the new client, is what are they exactly asking you to do?
They're not new. They're just new as an individual.
Okay.
They would like to present a clear case to USCIS with as much
Mhm.
documentation as they can that their former spouse was guilty of marriage fraud. That the whole marriage on which she
Well, what role? I mean, you as an attorney. I mean, what? Sometimes you do get these crazy. I call them crazy requests from people who ask you to do things that are kind of out of the wheelhouse. I mean, what would you? How would you even approach that? I mean, what would you even practically do as an attorney? I mean, write to the service center. How do you even know that it would reach a person, and how do you even?
Right. Well, I think I could handle that. I mean, let's just say it's in the Baltimore field office.
Okay.
I think I could confidently make a persuasive case and present it to the right people. But you're right. I mean, this is not your typical nudnik request that I get often from the arranged Indian marriage, where there's been abuse, and then one of the parties calls up and say, I really want to get back at my wife.
Right.
This is not this case. This is a case where it really does look like the marriage was fraudulent, and it was part of a greater scheme perpetrated by Serbians and Russians,
Mm-hmm.
who are well known for this particular kind of arrangement. It would perhaps be in the public interest to break it open and to expose it. Well, I don't, obviously I need to just go back and look at the model rules, because there are exceptions for criminal conduct, both for present and former clients.
Maybe this is a situation where you might want to get an ethical opinion ahead of time. You might want to get an ethical clearance. Might be a good idea.
Yeah. I think that's a first start, besides researching the rules oneself. So just throwing that out as a teaser, but it was a curious.
It is.
Curious case.
It is a curious situation.
Yeah.
David, you want to add anything on conflicts of interest?
Yeah, just more generally, I do think this area comes up a lot for immigration attorneys, particularly when you're doing family law. I must be bad for people's marriages, because maybe 30% of my couples who have hired me to do a green card as a joint representation will end up divorcing over time, usually much later, usually not quickly after getting the green card. But they still always call me. One of them, usually whichever one has an interest in kicking the other out, will call me and say, hey, this happened. And they usually want to tell you a long story too. And I try to avoid listening to those, knowing that this is built on a potential conflict of interest. So I will always remind them of the fee agreement that we signed, and that they agreed that if they were ever at odds with one another, that I would have to withdraw from representing them. And so I tell them right up front that they have to find another attorney, each of them, cannot rely on me for anything. Although sometimes they'll call me back and say, I just have a question like, what's the filing fee? So, or I just have a question like, how many days does it take to process this or that? Those kinds of questions, since they're not legal advice, I'll answer those to whichever party poses those questions. But then I remind them that I can't represent them as an attorney and have to get their own attorney.
Very good. Let's talk about terminating representation. Let's talk about withdrawal. So declining and terminating representation, this is Model Rule 1.16. And you want to, if you're going to decline a case, it's generally a good practice to use a non-engagement letter. If somebody comes in for the consultation, you're not going to take the case. Often can be a good idea to make absolutely sure that they know that you're not going to be representing them as an attorney. You may want to go so far as to use a non-engagement letter and let them know, something like, thanks for coming in. It was nice speaking to you. We cannot take your case. We're not going to be accepting your case, and good luck in finding other counsel for the matter. But sometimes a matter requires due diligence. Sometimes before you can decide whether to accept representation or not, you might need to obtain the complete file from DHS or from EOIR with a FOIA request before you actually can competently advise the client what their options are. If someone comes in with a tangled, or we say tortured immigration history, long history of filing things with immigration that haven't been successful, before you actually can analyze what their options are, you may have to file a FOIA and obtain the full file. So, you want to be clear in a writing to the client that you haven't yet agreed to undertake, representation of the case itself and seeking a benefit. You're merely still engaged in an evaluation of their case. Sometimes, though, you find yourself in a situation where you are representing someone and you have to withdraw. You may have to withdraw from a case if the client isn't paying your bills or if they're not cooperating with you in preparing their case. If you're in immigration court, you can file a motion to withdraw if you've entered an appearance. It used to be, but maybe our guests can confirm if it's still the case, that withdrawal is usually liberally granted so long as you have a cogent reason. Obviously, when you're withdrawing, you must give the client adequate notice of any coming deadlines. If they have an upcoming hearing or an RFE is outstanding, that should be communicated to them before you actually withdraw. It's a good idea when you finish up a case, successfully or otherwise, to use a file closing letter. Be sure to return the client's original documents and write them a nice letter thanking them for the opportunity to be of service and letting them know that the representation is concluded. Guests, want to mention anything about declining, withdrawing, or terminating representation?
Well, I'll mention something with respect to withdrawing, and that is to be extra careful in communicating no adverse information to the extent that you can in justifying your own motion to withdraw. It's not such a simple thing, unfortunately, in removal proceedings to withdraw properly. It's not meant to be under the case law, at least. And, how do you write a motion to withdraw that doesn't leave even a hint of a bad impression in the eyes of the immigration judge? For example, I've got a motion to withdraw that unfortunately I've got to write, it appears, this week, where the client I'm representing, a young girl, has just simply failed to, for whatever reasons, over the past 3.5 years that I've represented her, she's just completely failed to move forward properly on her I-130 petition so that we could ultimately either adjust status in proceedings or get termination and have USCIS adjust. She's had some emotional problems and we've had the pandemic, but it's pretty ridiculous now that she's been married almost 3 years. We don't even have an I-130 filed, and by the grace of God, in Arlington Immigration Court, we've had the case continued constantly, as is so often the case. And not even of our own volition. It's just worked out that way by fate. But it makes an attorney look like an idiot, obviously, that this amount of time has passed without any action being taken on the underlying application for relief. And I think my client, unfortunately, has proven herself, incapable of acting and so has her husband. So I've got to do this, and I've got to express it without actually expressing it. I think that if the immigration judge were aware, or if the immigration judge became too highly attuned to the failure of the client, that arguably hurts your client's position going forward, pro se or with another attorney. So I consider it actually something fairly delicate. You want to offer persuasive reason that you should be allowed to withdraw, but you don't want to give too much evidence or indication that the client is really incredibly lacking in diligence, which is really what's going on. It's a fine line.
It is indeed. One of our attendees here has asked a question about whether you're required to provide a reason to someone to whom you're declining representation, along with a non-engagement letter. What reason do you have to give if they insist on knowing why you won't take their case? Any thoughts?
I wouldn't think you have to give them a reason, not ethical.
You don't have to give a reason.
I wouldn't think so at all either.
No.
Some, it could just be a pure personality clash. You do not want to work with that person. And
You think they're going to be trouble.
And yeah, exactly. There's no reason you have a duty to disclose that to them.
Right. Well, attendees and guests, we have more ethical rules to cover, but we've gone a little bit over. We've generated a tremendous amount of substantive discussion. And I do know that other people have other obligations they have to get to this afternoon. Perhaps we can do a second ethics session perhaps in the future where we cover the remaining ethical rules. But I've very much appreciated having both of our guests here. Again, it has been David Cox from Illinois and Eric Singer from Maryland. One of our attendees has asked a question about whether someone would share a template of the fee agreement. My advice would be to do as I said earlier, join the Facebook immigration lawyer groups, and there I think you're going to meet up with many colleagues who will be happy to share templates of fee agreements. Also, AILA produces materials, including the practice toolbox, where there are templated fee agreements as well. Those would be some suggestions that I had.
And state and local bars also have templates like a fee agreements.
State and local bars as well. I guess I really appreciate it that you've been able to be with us today. And we will be posting the video of today's webinar on the DocketWise website for those who didn't get a chance to come in or who want to leave early. And thank you very much for attending.